One is here for the bond forfeiture docket.
Anyone present for the statement on forfeiture
No response, Your Honor.
Go ahead.
Your Honor, the state would request that the court take judicial notice of the court's bond forfeiture docket.
I will do that.
And we'd also request that the court take judicial notice of the bond forfeiture case and of the underlying criminal case of the court's files.
I'll take judicial notice of both of those as well.
Thank you, Your Honor. We'd ask that the court enter judgment according to the court's docket.
And I will do that as well.
And we have prepared judgments.
Thank you very much.
Thank you, Your Honor. May we be excused?
Yes, sir. Have a good day. I believe it's already October 20th.
I know, that's what I saw.
All right, if I call your name, please come forward. Bart Thibodeau. Good morning, sir. You're Bart Thibodeau? And Mr. Thibodeau, were you able to get a lawyer hired?
The one I've been communicating with, I just started a new job this morning. After I get out of here, 30 days wasn't near enough now, around that $4,000.
Where are you starting to work?
The Lord Chevrolet called me to get control.
Let me look at something real quick.
I have a rent house, it's been keeping me afloat barely, but I mean,
As a condition of your bond, were you required, or did I, or the magistrate require you to wear a drug patch?
No.
Okay, you've been getting that done like you're supposed to.
If I could get it off, because I mean, now that I'm working 5 10s over there at that dealership.
You're not going to get it off as long as this is pending. So what I'm going to do is give you 30 more days. Who are you talking to?
Justin Gilmore.
Okay, so I'm going to give you 30 more days to try to get him hired. If it's not going to work out with him, then talk to at least 3 others.
I'll talk to like 10.
Okay.
They all want the same thing.
Okay, let's see what you can do in the next 30 days. Also, bring me a pay stub since you've started working, and then we'll see what your options are at that point, okay? All right, step in front of the clerk, please, sir. Daryl Albritton. Morning, Mr. Parker.
Morning, Judge.
Good morning, sir. Are you Daryl Albritton?
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
I'm still looking. The good news, they got me working 7/12. They could have just started so I could be able to afford one.
Good.
They high.
Yeah. So who are you thinking about hiring? Or who'd you talk to at least?
I had talked to all of them.
Can you tell me who they are?
Justin, Orlando, Tristan, LeGrant, Michael.
Are you just telling me their first names? Tell me the
No,
full.
their first name and their last name.
Michael Trent,
Yeah.
Tristan LeGrand.
Where are they?
That's from Orlando dealer.
2 of them in Harris County.
Okay.
The rest of them out here.
Okay. So,
Some more too.
okay. So I'm going to reset your case one more time. It sounds like if you're working that much, you should be able to get somebody hired before. You've been coming for a little bit. It's time to get someone hired before that next court date, okay?
Yes, ma'am.
All right, step in front of the clerk. She'll give you a reset notice. Ryan Ramey. Good morning, sir. Are you Ryan Ramey? And Mr. Ramey, this is your initial appearance and cause number 25 DCCR 1246. You're charged with the state jail felony offense of driving while intoxicated with a child under 15. and that's from December 25th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Are you working? All right, so since you've made bond, I expect you to at least try to hire one. So what I'm going to do is reset your case for about 30 days. If you get someone hired before that next court date, then bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of those that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would have to go back to jail. Do you understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice. Tori Anderson. Good morning. Are you Tori Anderson?
I'm Tori Sanders. Mistake.
What is it?
Sam. They didn't put my correct last name. That's my
Okay.
maiden name.
What's your date of birth?
August 14, 2003.
All right, and so this is your initial appearance. Is it Sam Anderson's your maiden name? Okay, so Ms. Anderson, in cause number 25, DCCR 1165, you're charged with the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from July 31st of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I'm a lawyer. I had family come judge.
Okay, have you been looking for a job?
Yes.
Where have you been looking?
Walgreens, Dollar General,
Okay.
basic retail business.
All right, so what I'm going to do, Ms. Anderson, I'm going to give you about 30 days to see first if you can get a job. So I want you to be applying to at least 5 a week. You should be doing more than that. If you get a job, bring me some proof of that when you come back. If not, bring me proof of where you've applied, okay? In the meantime, also, I want you to be talking to some attorneys so you know how much they cost. And bring me the names of those you've talked to, then we'll discuss what your options are, okay? So if you still haven't found a job, there may be a time when you qualify for a court-appointed lawyer, but I want you to at least go through this process. I want you to try to get a job, and I want you to try hard before that next court date, okay? All right, step in front of the clerk. She'll give you a reset notice.
If you need to, what, how can I be? If you need to,
I should have tested.
you need to go.
There she is.
Here, hold on. Thank you.
I should have tested. You her lucky day. Terrell Coker. Good morning, sir. Are you Terrell Coker? And Mr. Coker, this is your initial appearance in cause number 25 DCCR 1221. You're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay, so what I'm going to do, Mr. Coker, is reset your case about 30 days to give you some time to get him or someone else hired. All right, if you get him hired or whoever, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you a reset notice.
Sign right here.
Tiffany Elair. Good morning, ma'am. You're Tiffany Elair? And Ms. Elair, were you able to get someone hired?
So I took money.
Speak up just a little bit.
I had to resign. So
Okay.
I took money out of my TRS to go ahead and pay for a lawyer.
Okay.
Instead, I'll be doing it finally.
Okay, perfect. So what I'll do is give you 30 days to get him hired. Bring the reset notice that you get to him and he'll tell you what to do. If for some reason that's not going to work out, then make sure you either get someone else hired or visit with some others and bring me those names, okay? All right, it was Kyle Walker. Jalen Eli. Good morning. You're Jalen Eli?
Yes, ma'am.
And Mr. Eli, this is your initial appearance in cause number 25 DCCR 1004. You're charged with the state jail felony offense of forgery of a financial instrument, and that's from August 8th of 2025. Since you've made bond in your case, if you had an opportunity to try to hire a lawyer.
Yes, ma'am.
You already hired someone?
I ain't hired no one, but I'm like in the process of hiring one.
Okay, who are you gonna hire?
Bronx,
Burbank?
yeah.
Okay, so what I'll do, Mr. Eli, is reset your case about 30 days to give you some time to get Mr. Burbank hired. If you get him hired before the next court date, just bring the reset notice. You need me? Oh,
You need me now or?
no, I'll come visit with you later, thanks. If you get him hired before the next court date, I had to rewind for a second. Did you see that? It happened. If, just bring the reset notice to him, he'll tell you what to do. If for some reason, go ahead.
Oh, I was saying, I work at FedEx Long with 5 hours from Monday through Friday, so it's 30 days. It's kind of hard for me to get.
So it's going to be a little bit longer anyway, just holidays and things like that. If you're not getting enough hours, you might want to go out and try to get another part-time job or something like that as well. Perfect. So just see what you can do to get him or someone hired before the next court date. If it's not going, if you make payments toward him, then bring me receipts. If you're working, maybe bring your pay stub so that I see how much you're working. Whatever you can bring me that will help, okay? If it's not going to work out for some reason with Mr. Burbank, then visit with at least 3 others. You'll see they all charge different amounts, have different payment plans, and we'll discuss your options when you come back. If you do all that and need some more time, then we'll work with you, okay? All right, step in front of the clerk. I literally went, I did. It helped. Whatever it takes. I do need to visit with him about that. Crystal Latulas. Good morning, ma'am. You're Crystal Latulas. And Ms. Latulas, were you able to get someone hired? All right, who'd you talk to?
This one's for Marcus Wilson, Shalonda Law Firm, the Goulas, Leslie Law Firm.
The what? Say the last one?
The GERTZ
Oh, Gertz, uh-huh.
Law Firm, Lorraine and James Macon.
Uh-huh.
So I advertised.
All right, and so where are you gonna be able to get somebody hired? Are you working? Okay, where you work? Okay, so what I'm going to do, thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, okay? Step in front of the clerk and she'll give you that. Lisa White. Lisa White. Good morning, ma'am. You're Lisa White. Come on up. And Miss White, were you able to get someone hired?
I went to pay for a confrontation with Mr. Rojas and Mr. Samuel and Mr. Cole Crenshaw for $30,000.
Okay. And are you working?
I started unemployment this week.
Okay. So what I'm going to do, Ms. White, thank you for doing what I asked you to do. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely because you're going to swear under oath that it's all true and correct, okay? Step in front of the clerk. She'll give you that. Looking at her PC.
Dalton Frazier.
It's aggravated assault. She chased down another lady and hit her with her car twice. Yeah. Just gonna dry up those tears real quick. Rakeem Allen. So weird. Like this, his didn't print together on the docket. This one. Good morning. Are you Rakeem Allen? And Mr. Allen, this is your initial appearance in cause number 25, DCCR 1163. You're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 7th of 2025. And then in cause number 25, DCCR 1164, you're charged with possession of a controlled substance, and that's also from June 7th of 2025. Since you've made your bond in your cases, have you had an opportunity to try to hire a lawyer? So have you hired someone?
Not fully. I'm fully. He basically my lawyer. I gotta go pay him today.
Who's that? Okay. And are you wearing a drug patch?
I don't know.
Were you ordered to wear one?
I was, but once they changed my bonding company, that's what they tell me about.
So, but the magistrate told you you had to wear one when you got out of jail, right?
No, I'm on 2 different bonds. So I guess the other money I had already got that paying them off, so I didn't have to transfer them anymore.
Okay, so you're gonna have to wear one for me, but what first we're gonna do this morning is have you tested to make sure you're clean. Have a seat in the jury box. Well, because on this docket, it shows on
I use it together.
together.
Charlie wasn't put in on the second case.
Oh, gotcha.
That's what the attorney's on.
Can you tell, can y'all look back on that possession case at the bonds from the jail for me real quick and just see if the conditions were written in on that one while I'm... Terrence Currington. Good morning. Are you Terrence Currington? And Mr. Currington, this is your initial appearance in cause number 25, DCCR 1114. You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from July 13th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? I'm sorry? Okay, so what I'm going to do, Mr. Currington, is reset your case about 30 days to give you some time to try to hire someone. If you hire someone before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk right here. She'll give you your reset notice. Kayla Provost. Good morning, ma'am. Are you Kayla Provost?
Yes.
And Ms. Provost, did you get someone hired?
I've been talking to Mr. Langston,
Okay,
and I reached out to him, but I think I'm gonna go with Langston.
okay,
However, I haven't got a job yet, but my teacher, I had graduated school like 5 months ago.
uh-huh,
And she reached out to me for an internship that was supposed to start today.
okay.
So,
Is it a paid internship or?
yes, it's supposed to be paid.
Okay,
For the lottery.
I'm sorry?
For the lottery.
Okay,
So, Yeah, I was gonna reach back out to her to see if I could start tomorrow.
Okay, so if, what I'll do, Ms. Provost, is I'll give you another reset to get you hopefully started on that job and where you can hire one of those attorneys. If that works out, great, just get them hired and bring the reset notice to them and they'll tell you what to do. If for some reason it's not gonna work and you're not making that kind of money or whatever, bring me a copy of your pay stub if you are working and talk to some other attorneys and bring those names and then we'll discuss your options, okay? All right, step in front of the clerk, she'll give you a reset notice.
For some reason, the magistrate report is not in there.
Oh, really?
But it just says standard bond conditions on the record.
And see, that is, but it should, standard bond conditions for a drug case are different. You know,
Right. And that's why it's marked in the pay.
maybe make a notation to see if Christy can locate those.
Yes, ma'am.
Whitley Shepherd. I still smell coffee in my hand. I have to go wash my hand. Good morning, you're Whitley Shepherd? Okay, and Ms. Shepherd, this is your initial appearance in cause number 25, DCCR 1146. You're charged with a second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 1st of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Shepherd, is reset your case for about 30 days to give you some time to hire one. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to when you come back so I know you're trying and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would have to go back to jail. Do you understand? Also, a tracksuit type thing is not appropriate for court. You need to wear something else next time. Do you understand? Yes, ma'am. Step in front of the clerk. Kyle Whittington.
David Jones.
Good morning, sir. You're Kyle Whittington. And Mr. Whittington, this is your initial appearance in 2 cases. The first is 25 DCCR 0924. You're charged with possession of child pornography, and that's from July 29th of 2024. And cause number 25 DCCR 0925, you're charged with online solicitation of a minor under 14, and that's also from July 29th of 2024. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
Not yet.
So what I'll do, sir, is reset your cases for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to when you come back so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Understood.
All right, if you'll step in front of the clerk, she'll give you a reset notice.
Should I in?
I'm doing 5 things at one time.
Well, that's
So Sunny earlier. See, Mr. Comerford. Good morning. Are you ready on Farrell Gilbert?
Yes, ma'am.
Is it Farrell? Probably. Farrell. Let's see. It's Mr. Smith. Farrell Gilbert. Good morning, sir.
Good morning.
Are you Farrell Gilbert? Is it Farrell or Farrell?
Farrell.
Farrell Gilbert. And this is cause number 25, DCCR 1009. Mr. Gilbert's charged with driving while intoxicated, third or more. And what is the announcement?
I just picked up the media footage today, so I just need some more time reviewing that.
Sure. Any issues? So, Mr. Gilbert, I'm going to reset your case about 30 days or so. Make sure you make an appointment, go visit with your attorney now that he's gotten all of the media. Y'all can go over everything, and we'll see if we can get an announcement at the next court date. All right. Thank you. Y'all are free to go.
Thank you, Judge.
See, Mr. Parker, you've got Dalton Frege. That was Farrell Gilbert. Farrell, I want to rename him. Morning.
I have an 18-year-old.
That's crazy. You're getting old.
18? Yeah, he turned 18 today.
Good morning. Are you Dalton Frege? And will your client waive the formal reading of the indictment? Mr. Frege, in cause number 25, DCCR 0404, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from February 6th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Frege is not competent?
There you go.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there. Okay, we'll see you back at sentencing.
Thank you, Your Honor.
See, Valerie Hale. Good morning, Mr. Horn. Good morning, you're Valerie Hale. And will your client waive the formal reading of the indictment?
Here you go. I don't think I put on the paperwork got interlocked, Judge, but that's part of the plea agreement.
Okay. All right, Ms. Hale, in cause number 25, DCCR 0573, you're charged with the state jail felony offense of driving while intoxicated with a child under 15, and that's from March 13th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. ordered to pay a $1,000 fine, and to follow all of the rules and conditions of probation, including having an auto ignition interlock device on your vehicle. Do you understand? Do you have one now?
Yes.
Okay, I was about to say, you should already have one, and so that'll be part of your probation, at least for some amount of time as well. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number one.
No objection?
It's admitted. Is there any evidence that Ms. Hale's not competent?
There you go. We'll waive the PSI.
What kind of history, if any?
Absolutely none, Judge.
Okay.
Just go to my file.
All right, so Ms. Hale, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea. Waive the pre-sentence report, find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and condition of probation, including continuing with that interlock device until further order of the court, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. And so this is for you, for this probation, this is for all practical purposes, your case here in court is over. And you'll be able to serve that 2 years while you're out on probation instead of in the state jail prison. And if you do everything correctly, you'll never be back in court. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've agreed to. Do you understand? All right, you just need to have a seat here in the courtroom. Probation, she's in at that desk right there. She's going to call you up when she's ready to go over your paperwork. Okay? Yes, ma'am. Good luck.
From around.
David Jones. See Mr. Smith on David Jones.
It's one of Mr. Hoffhauer.
Oh, I'm sorry. I read the wrong one. It's Mr. You're right. Let's see. Good morning, sir. Are you David Jones, Jr.? And Mr. Parker, will your client waive the formal reading of the indictment?
You go, Your Honor.
Mr. Jones, in cause number 25, DCCR 0124, you're charged with the state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
And with regard to history?
He has one arrest for a misdemeanor 12 years ago, Your Honor.
So no objection to me waiving the pre-sentence report?
No, Your Honor.
Mr. Jones, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you're successful, the case is dismissed. You'll never have the conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? Also, if you get started on probation, you do everything you're supposed to, get the community service out of the way and do everything else, then I sign early terminations all the time as well. And so there's no reason that you wouldn't get off early if you do everything you're supposed to as well. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I hinted on something I didn't need to. There we go. All right. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's sitting at that desk right over there, so just watch for her to call you up. Okay? Good luck to you, sir. I don't know what's up. Your thing's off again. So if y'all will put a ticket in and remind me to call, we've got to do something to get it fixed. Christopher Morale. Good morning. Are you Christopher Morale?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Here you go.
Mr. Morale, in cause number 25, DCCR 0466, you're charged with the third-degree felony offense of continuous violence against the family from February 8th of 2025. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with?
Yes, ma'am.
I have here on the tablets some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am, I did.
And do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including entering and successfully completing an anger management program. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Morale is not competent?
There you go.
And as a condition of your bond, is it already, you should already have a condition that you're not to have any contact at all with Alonda Kelly?
Yes, ma'am.
Okay, so I want to make sure that you're still under that bond condition, that it will likely be a condition of your probation as well.
Absolutely.
So I want to, if you violate that and have any contact or communication with her whatsoever before sentencing, then I don't have to accept this agreement. Things could be much worse. Do you understand?
Yes, ma'am.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you, Mr. Parker. Mr. Allen? When did you smoke marijuana last? So here's the thing, you need to tell me the truth, because I'm gonna get a quantity amount, not just that you're positive, but I'm gonna get how much is in your system. And so I need to know when you smoked it last, so that if I find out next time it's not going down, things are gonna be worse. So when did you smoke? When did you smoke last? Day before yesterday. So that's why you weren't wearing your patch.
No, really, I just, like I said, I'm on 2 different levels. I was already done doing my first one.
Right.
I'm gonna zip on the first bill, and that's why my blood pressure. I figured since I wasn't paying bill money anymore, I had to let blood pressure. They haven't been getting covered.
I know, that'd be really convenient if you had 2 felonies and you didn't have to wear a drug patch and you could smoke marijuana 2 days before court. That'd be pretty convenient, wouldn't it? So you're gonna have a drug patch today, within 24 hours. I know the first one will be positive, obviously. If the next one is not going down, then your bonds in each of your cases will be raised and you will be back in custody. No questions asked, you understand? So you have 24 hours. I want you to get confirmation of that to your bondsman. Even though you've paid your bondsman, they're still your bondsman. They're still gonna give you, just because you paid them off doesn't mean they're not your bondsman anymore. Okay, so even if you pay off the other one, you're still out on bond. You're still required to keep in touch with them. They're the ones who'll help you figure out when your court days and all of that stuff. So don't stop communicating with them, because even though you've paid them, they can get off your bond and you can go back to jail. So keep up with everything you're supposed to. I want proof to them by tomorrow or this afternoon that you have the drug patch. You need to make sure it's switched every 2 weeks like it's supposed to. Wear it properly. There's no going in and saying, well, it fell off, and none of that.
Even when I was on blood pressure, I ain't never feel no good.
Okay, well, that makes me more concerned about your decision making if you were doing well and then you decided right before court to go smoke, right? Okay, step in front of the clerk. She's gonna give you a reset notice. You need to get a lawyer hired as well before that next court date.
Fine.
Oh, sir. That's not appropriate. First of all, pull them up. I know. Well, nobody wants to see your underwear. Not in court and not anywhere does anybody ever want to see your underwear, right? And you need to wear something nicer when you're coming to court. Yes, ma'am, sure. Uh-huh. Let's see, you're Deshaun Robertson?
Yes, ma'am.
And this is 25 DCCR 0914. Mr. Wilkerson has filed a motion to withdraw, correct, Mr. Wilkerson?
Yes, Your Honor.
Ms. Robertson, do you have any issue with me allowing Mr. Wilkerson to withdraw as your attorney? All right, then I'll grant that motion, Mr. Wilkerson, and sign that order. And so, Ms. Robertson, are you able to hire an attorney?
I just got back at the hospital. I had me with RNA, so I had surgery. And I just started going to work on the
Okay, and where are you working?
at risk care. Take
So-
care of people with disabilities.
So what I'm going to do is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. I'm going to take a look at it. You're going to swear under oath that it's all true and correct, and then I'll see if you qualify for a court-appointed lawyer. All right? Step in front of the clerk at the end, and she'll give you that paperwork. Thank you, Mr. Wilkerson.
Thank you, Your Honor.
You told me to make sure I do.
Okay, so you did that as well?
That was a condition of her bond.
Good.
And I know no problems.
Good. So keep doing everything you're supposed to, and keep those so that if we need them, we'll have record of that you're going, okay? Thank you, ma'am. She's good.
Thank you.
Let's see, you didn't already print that order, did you? For Wilkerson's withdrawal? Did you? Because I just did it also, so we're gonna have two. It is Robertson. So, throw away what I just printed.
Crystal, what's your list?
Mr. Vasquez, you have Veronica Randall.
Yeah, Sean, can we hold all that?
Yes, sir. Mr. Rojas, Michaela Marcantel. Morning.
Good morning. We've emailed the attachment.
Okay, thank you. Good morning. Are you Michaela Marcantel? And will your client waive the formal reading of the indictment?
She will, Your Honor.
Let me get to it. Ms. Marcantel, in cause number 25, DCCR 0528, you're charged with the state jail felony offense of theft of property from May 28th of 2022, continuing through June 4th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be $4,492.45 to be paid back in restitution, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Marcantel is not competent?
No, Your Honor.
And any reason not to waive?
She's never been arrested before, Your Honor, and I don't
We've
have
got the
objection
amount.
waiving.
All right, Ms. Marcantel, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. I'm going to waive the pre-sentence report. find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. I'm also ordering you pay back the restitution in the amount of $4,492.45. If you do everything that you're supposed to on this probation, this is an excellent opportunity because you are not a convicted felon. You don't have the conviction on your record. And if you successfully complete the probation, at the end, the case actually gets dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand? That's a lot of money to pay back also. 5 years seems like a long time to pay it back, but it'll sneak up on you. And so it is very important to me that you start paying back that money immediately. Even if you pay a little bit a month, it'll add up. What can happen is you can do everything else you're supposed to on your probation. And if we get to the end of the probation period and you have not paid that restitution back, and I make a finding that you could have, you could still get revoked to go to prison after you've done all that probation. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She's going to call you up when she's ready to go over all of your paperwork. Good luck to you, ma'am. Carnell Beard, it's a excuse me, it's a sentencing, Mr. Rojas. Good morning, sir. You're Carnell Beard?
Yes, ma'am.
And Mr. Beard was previously in court, and you entered a plea of guilty to collision involving serious bodily injury. And I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
Any additions or corrections?
No, Your Honor.
There was a notation that restitution was to be determined, but I didn't see that there was any. Ms. Malfino, does the state have any notation or request, or did I miss it?
I did send Mr. Davis the complainant a restitution request form. I have not ever heard back.
Okay.
So at this time, I don't feel like I have something to stand on the order.
Okay. All right, then, Mr. Beard, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. And if you do that, this is an excellent opportunity because you don't have the felony conviction on your record. And at the end of the probation period, if you're successful, the case is actually dismissed and you'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could go to prison for up to, is it 10? I'm sorry.
Just
20.
so the record is clear, it's 20. We've
20
led
years.
to count 20.
Okay, so you could go to prison for up to 20 years if you violate your probation. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir.
Thank you, Judge.
Thank you, Mr. Rojas. Let's see. Mr. Kimler, are you ready on Brianna Kleinen?
I would be if I had it out, you know.
Okay, I'll hold it. And then what about Ryan Hodge?
I'm speaking this both of you.
Okay, I'll hold that as well. And Richard Robb?
Further speaking.
Judge, we've come to a resolution on that, and we made this, there's no restitution that was determined, and so I think we haven't resolved other than it.
Other than what, I'm sorry?
Other than that here, Judge.
Oh, okay.
We can take it off of our document.
Okay, y'all are gonna take care of it down the hall?
Yes.
Okay, so I'll just do a normal reset to give y'all time to get that done. If it gets done, just let me know and we'll sign the dismissal when it comes through.
Okay, thank you.
Thank you. Let's see. Mr. Galmore, you've got Kelton Hebert. Good morning. How are you?
Fantastic.
Are you?
It's Monday morning.
It is. All right, sir, you Kelton Hebert?
Yes, ma'am.
And this is 24 DCCR 1498. What is the announcement?
Judge, if we could have 2 weeks, Mr. Hebert was not able to come to my office since our last court date. There's a particular video he needs to watch. He's been working too much, but we'll make those arrangements if we can just have 2 weeks.
Okay, so this will be the final reset. You need to figure it out. I appreciate that you're working, but find a time to go visit with Mr. Gallimore before that next court date. It'll likely be 3, just because we're down, but,
I looked at my calendar, both of those are fine.
okay, all right. Stay in touch with Mr. Gallimore. We'll see you at the next court date.
Thank you.
And then you have Duma Turner. This is Mr. Hoffpowers. Good morning, sir. You're Duma Turner?
Yes, ma'am.
And in 24 DCCR 1998, Mr. Turner, you're charged with criminal mischief, and what is the announcement?
Judge, if we could just have a normal reset on this one, not had an opportunity to review all the discovery yet.
Looks like you were just got on in August. Any issues that you see?
No, Judge, it looks like there should be an offer in there and the restitution amount has been determined.
All right, so Mr. Turner, I'm going to just do a normal reset, about 30 days or so. Make sure you visit with Mr. Gallimore before that next court date. We'll see if we can get an announcement.
Sounds good.
All right, you're free to go. Thank you.
Judge, that's all I have.
Thank you, sir. Have a good day. Mr. Macon, you have Thomas Fisher sentencing.
He's present, Your Honor. Good morning, Your Honor.
Good morning. Good morning. Are you Thomas Fisher?
Yes, ma'am.
And Mr. Fisher was previously in court and entered pleas of guilty in cause number 23 DCCR 1046 to aggravated assault with a deadly weapon and 23 DCCR 1047 criminal mischief, a state jail felony. I've received that pre-sentence report. Has everyone had an opportunity to review that?
Yes, Your Honor, we have.
Are there any additions or corrections?
No, not most.
All right, sir, I'm going to find in each of those cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. However, I'm going to follow the agreements in each case. In cause number 23, DCCR 1046, defer all proceedings for a period of 5 years, place you on probation. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. And then in cause number 23, DCCR 1047, also defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine in that case as well, and to follow all of the rules and conditions of probation. This is an excellent opportunity because you have no felony conviction on your record. And so if you successfully complete the probations, then you will never have felony convictions, and at the end of the probation period, the case will be dismissed. One of the conditions of your probation is going to be that you participate in any and all mental health services as well as drug treatment. Whatever they say is necessary, then you're going to be ordered to participate in those, whether you think you need it or not. It's now part of your probation. And so all of that is meant to help you to stay on track and do what you need to do so that you can be successful. Also, you're specifically ordered you cannot have any contact with the victim, who is Michaela Stacy. That's also obviously contact in person, but that's communication in any way. You can't send messages, you can't send anything electronically through social media or anything like that. If you do, or you're around her at all, then obviously that's a violation of your probation. You're going to be right back in here. If you violate your probation in these cases and you are brought back into court, you could be found guilty in each of your cases. And in the first case, you could go to prison for up to 20 years. And in the second, I believe it's a state jail felony, you go to prison for up to 2 years. Do you understand? I'm handing you in each of your cases the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. And then I will sign a dismissal in cause number 23 DCCR 1751 as part of this plea agreement. You need to have a seat here in the courtroom. Probation will call you up to her desk as soon as she's ready to go over your paperwork. Good luck to you, sir. Thank you, Mr. Macon. Was he hired or already appointed? He was hired. Yeah, just one of ours.
Okay, I just want to
No, I don't think it's anything special. Ms. Holmes, you have Roland Guillory sentencing.
Yes, sir.
Good morning.
Good morning.
Good morning, sir. You're Roland Guillory. And this is 24 DCCR 1568. Mr. Guillory was previously in court, entered a plea of guilty to the lesser included offense of a Class A misdemeanor abandoning or attempt to abandon or endanger a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
Just that I've reviewed it with Mr. Guillory. He would like the court to move forward with the plea agreement, and we understand the recommendations of until for parents and classes, and until that is completed, for him to have supervised visits with the child, and also with MHMR.
Yes.
He's tried several times. Their system has been down for quite some time, but he said they were able to get him scheduled in.
Okay, good.
November 11th.
Okay.
Yes, ma'am.
All right.
No additions or corrections, Judge. I do have some concerns, particularly on page 1 under the defendant's version where he says he doesn't feel like he committed a crime.
I think that's an issue as well. I think with regard to that, probably some of the other issues that hopefully we'll address on the probation, and the fact that it was reduced to a misdemeanor probably covers that, but I did have the same concern. But I think I'm going to go ahead and go forward. Are you okay with that, Mr. Coleman? Okay. Mr. Guillory, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings, place you on probation for 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes participating in the through Spinal Top and whatever the recommendations are through that caseload on probation, completing the parenting class, doing everything you're supposed to, and then not having there's no unsupervised contact with any child until further order of the court. So if you go through all those classes and you're well on your way and you're following all the recommendations and following through with Spinal Top, there may be a time where probation sends me back something that says, hey, he's doing great, we're ready to do unsupervised, but you're going to have to do everything you're supposed to. If you do everything you're supposed to on this probation, then this is an excellent opportunity because you don't have the conviction on your record. And if you complete the probation, then at the end, the case will actually be dismissed. The other side of that is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, sir. Let's see. Cafeta Jones, I just signed that dismissal. She's free to go. He's free to go, I'm sorry. And then Seneca McDaniels, Ms. Holmes.
Yes, Deshaun Robertson, that's Ashley.
This one will be taken care of, this one outside of, down the hall.
Good morning, you're Seneca McDaniels, and this is 24 DCCR 1915. Mr. McDaniels is charged with unlawful possession of a firearm by a felon. Go ahead, I'm sorry.
Your Honor, we have an agreement in which this will be taken care of down the hall as well.
Okay.
So we can get a couple of weeks.
And he's already paid the fine, Judge. I will draw up a forfeiture document. He will sign it in Ms. Holmes' office, and we should take care of it.
All right, so I'll just do a normal reset. Obviously, if it gets taken care of before that court date, then you can just let him know. Otherwise, make sure you're here on that court date if nothing has been done before then, okay? All right, you're free to go.
Thank you, Judge. It'll be done.
Thank you. You've got a Zully Valicia as a sentencing.
Yes, Your Honor. I don't know how to read this. So you don't know.
Mm-hmm. We'll see.
Okay.
Good morning, you're Zully Valicia. And Ms. Valicia, you were previously in court and entered a plea of guilty to burglary of a habitation, a second-degree felony. This is 24 DCCR 1364. The agreement was for a cap of 7 years in prison. I've received the pre-sentence report and reviewed it. Has everyone had an opportunity to review it?
Yes, Your Honor.
Yes, sir, we have.
Any additions or corrections?
I've reviewed the PSI with Zuli. I know that obviously her version, the court has questions about that, and so I would allow her to address that if she does wish to move forward in hopes of obviously us arguing for the probation.
So here's the thing. If you say you didn't do it, you don't get to say I didn't do it, but please give me probation, because then you're not accepting responsibility. So either you did it, what they charged you with, or you didn't. And doing it doesn't mean that you participated fully, and I'm sure Ms. Holmes has explained to you the law of parties in Texas and what that means. But if you say somebody took your car and you weren't even there and you had no idea of it, then that's what juries are for. Because you are about to take the chance, if we go forward, of me sending you to prison for 7 years. Me possibly giving you probation. But I can assure you that you're not going to get any kind of help from me if you get up here and say, well, I didn't really do it, but come on, give me probation. Does that make sense?
Yes, ma'am.
So tell me, if you want to go forward, tell me exactly what you did, what your part of this was.
I was aware of what my car was going to do. I didn't participate in the act, but I...
So you didn't drive your car?
No, I did not. I did not drive it at the scene where it happened.
Mr. Nichols, it appears that the...
If I'm explaining myself.
I think what she was trying to say, Your Honor, she wasn't present at the scene of the burglary, but let them use her car and I guess drove them close by. Because we know she was pulled over driving that vehicle on the way.
I mean, there's cameras from Lieutenant Hudson's cameras that confirm that you were driving when you were stopped.
Yes.
With the other guy seated in the front seat.
I was in town when it happened, but I was not at the scene.
So, yeah.
So when did he get in your car?
When they brought it to the crime scene, but I was not at the crime scene.
I'm very confused.
So she drove here to Groves. She drove into town. She was aware of what was going to happen.
You weren't aware of it. You drove in to be a part of. You knew. I mean, there's saying I'm aware of whatever. Y'all came into town.
Can I rephrase myself?
You probably should real quick, because hang on.
I was not at the crime scene.
Hold on. Because y'all came into town with radio jammers and fully ready with medical mask and face mask and all this stuff to come in from out of town to do what you did here in our town. And so you weren't just riding along and then they said, oh, by the way, sorry you came with us, we're going to do this.
Okay, well, I drove because I'm the one that had the license, so in case we got pulled over.
Okay.
I was not at the scene.
So you brought them to do the crime?
Yes, ma'am.
It's not that hard to say.
I didn't know how to rephrase it myself, I'm sorry.
All right, Ms. Holmes, go ahead with argument.
Yes, Your Honor. She does not have an extensive criminal history. As you can see, there is one prior, looks like a theft of property, which she received 6 months state jail. And then there was a federal case as well back in 2020. Ms. Zuli is currently employed and working. She would like the opportunity to continue that with probation. She does care for family members as well, Your Honor, for a household. As indicated in the PSI, they do have her at a low risk level, which I believe is indicative that she would be successful on probation if given that opportunity. They've also stated in the PSI that they would like her to adhere to any mental health services and comply with those recommendations, as well as the moral recognition therapy program, and to obviously stay off of any premises in which this act was committed. To her credit, they did state that she did express remorse for the actions, and she felt embarrassed for her family and does regret that. Your Honor, it's also stated that based on her statements of history and circumstances, she does appear remorseful and motivated to make positive changes, which I believe that she can do if given that opportunity on probation. She can get obviously up to 10 years, and if the court deems that, we are asking that she be able to do the 10 years probation to give her that opportunity to show that she can be a productive member of society, and to possibly, if the court deems necessary, if she can have the opportunity at deferred probation to have that time to rehabilitate herself and to hopefully not have another felony conviction on her record.
Mr. Nichols?
Your Honor, I echo the sentiments of Detective Hudson and, Lieutenant Hudson. This wasn't just a crime of opportunity or one-off incident. This was an organized burglary that involved high technology, that involved planning, and targeted this individual's residence. They came in from Houston specifically to burglarize this home, and they did. And I think there's obviously, she flat out lied to the police about being there, driving. She claimed that her car had been reported stolen 2 days before this, even though she was stopped and is on video driving the morning of. So I think the 7 years is appropriate. I'll note for the court, the co-defendant got 10. At least one co-defendant got 10. I'm not sure on the others. But I think 7 years is appropriate, and given the incidents in this case.
How'd y'all pick this person?
Sorry.
How did y'all pick this house, this person, to come in?
No, like I said, the only reason why I came here was because I had the license. So in case they got pulled over, they didn't have a way to prove their citizens. So I was just like the one that drove into town. I don't know about the...
And if I can, 2 of those individuals have fled the border. They were not legalized, so they probably will never be found. So there were 2 other individuals involved in which she has tried to get contact. So that's the reason why they were involved. She was the driver, but they have since fled the country. They're not coming back. That actually went into the house. There was only one that was caught that received the 10.
Mm-hmm.
So I think that's what she's trying to say is she was driving because they obviously did not have the credentials to do that. And we don't know where they are.
So do you know why y'all came to this house?
I have no idea. The only reason that I came into town was because I'm the one that had the license. So in case they got pulled over, they didn't have a way, to prove their legal
How many
status.
other times did they have you drive you to other places?
No, that was the only time I did it, and I regret it. It was crazy.
Your Honor, if I may, I had the co-defendant's case. The victim in this particular instance was a local business owner, owned a donut shop. They also owned a donut shop in and forgive me if I'm off on this, the exact city, I think somewhere in Humble, or nearby in Humble, that business, their home in that city was also burglarized.
Right. So, I mean, right, thank you,
I cannot
Mr.
show you I was not involved in any other situation that had to do with them. It was just a one-time thing.
How did you know these guys?
Well, basically one is my barber, the one that just doing time, he's my barber.
He's your brother?
Barber. Yes.
What about the other two that took
No,
off?
I never knew them.
So where do you live now?
I live in Houston, Texas. Yeah, Houston, Texas.
Do you work?
Yes, ma'am.
Where-
50 hours a week.
For what? For who?
It's integral. It's basically for the state. I get paid $25 an hour.
To do what? I'm sorry?
I don't know how to describe it. It's like solar panels. It's for the state.
Okay.
I have evidence as well.
You have what?
Evidence that I'm working there.
Okay.
Before that, I was working at a car wash, but they offered me more there.
So, I don't disagree with Lieutenant Hudson or with Mr. Nichols, because of what happened and the targeted way that this happened. It does appear that the guys were probably in charge of most of this. You made a really, really stupid decision.
I did. And I regret it.
Yeah. All right, what I'm inclined to do, because what you're charged with is a second-degree felony. So, the range of punishment is up to 20 years if you went to jury, or all right, here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're going to be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. So let me explain what that means and why that's good for you, but probably more so for me, and why I'm doing this. So a deferred probation means you don't have this conviction on your record. But what it also means is if you violate any condition of probation, you will be brought back into court, found guilty, so you have the felony conviction, and that cap of 7's gone. I have the full range of punishment between 2 years and up to 20 years. And certain cases, for whatever reason, the fact that this one, I remember it from Mr. Coleman's case, from the co-defendant. I'm likely to remember it. It's never good when I remember things, okay? And so I'm going to order also that you obviously have no contact or communication with any of the co-defendants. If they've fled the country, whatever, if they come back, if they try to contact you, you cannot have any contact with them. In fact, I'm ordering, if they contact you, that you contact your probation officer and law enforcement and let them know any information that you have about where they are. You will be, I want her on the medium-high caseload to start off with. It means you're going to be reporting more often, making sure you get off on the right track.
I I work like an hour from my house, so I leave the house at 2:30 and come back home at 2:30 in the morning.
So talk to probation. I want you to work, okay? And so you need to get them documentation of your schedule because there will be a curfew except for employment purposes. You'll be required to report in Harris County, but you're also going to be required to report by mail or online here. So you kind of have double duty. You've got to do it all. If you don't report by mail or online here, it's a violation. If you don't go in person there, it's a violation. If you don't give them proof of where you are when you're supposed to be, it's a violation. If you test positive for any drugs, whatever it is, you're going to be on a high caseload so that I know, at least for some time, that you're doing exactly what you're supposed to be doing. And if you don't, you will be right back in here. Do you understand? All right, I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she'll call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am.
Thank you, Your Honor.
Mr. Lewis, you have Jaron Crane, 3 cases. Good morning.
Good morning.
Judge, just to refresh the court's recollection, this is the case you allowed us to reset Mr. St. Clair as co-defendant.
Yes.
On Mr. Crane.
So are we going to go forward? I mean, do we already have a rejection? And
Judge, I got an
well, it's
offer.
Jaron Crane. All right, sir, you're Jaron Crane. And Mr. Crane, you're charged in cause number 23 DCCR 1082 with evading arrest or detention with the use of a vehicle. In cause number 23 DCCR 1406 and 23 DCCR 2233 with aggravated robbery. And what is the announcement?
Judge, we've gotten a new offer, or gotten an offer on Mr. Crane, and I've given it to him and talked to him about it. I was gonna ask for a short reset, maybe like 2 weeks, just so we can talk to his parents. And I think that it'll be resolved at that point. It won't be.
Okay. Any issue?
No, Judge, that's fine with me. I just want the court to know it's no longer any type of a probation offer that the state is extending based on the nature of where we got last week with Mr. Crane.
Right.
For some reason, that attitude changes. We'll approach the court with that, and I appreciate you letting us hold on that. It is my intention, I want Mr. Crane to know from me, it's my intention to go on his case to trial first and ask that any sentences that can run consecutively, run consecutively.
So, Mr. Crane, I'm going to reset your case a couple of weeks. We're done playing games, all right? So, if you were, whatever all happened, if you've changed your mind, it doesn't matter to me. I don't care. But we're not putting your case off for someone else's case anymore. Your case is going to go forward. You have 2 weeks to make up your mind on if you want to accept this plea agreement or not. If you don't, then we'll get your cases set for trial very quickly, and your case will go to trial. And after that, I'm not accepting plea agreements and all of that. So this is where you need to talk to your attorney, family, whatever you need to do. When you come back, I want to know either we're taking a deal that day or you're going to trial. Doesn't matter to me which way, but we're not putting it off anymore. We're not going to say we're going to do this or that and then get your case put off. It's going forward, okay?
Yeah, Judge, we can be prepared very quickly. I've already prepared all witnesses in lieu of the other trial.
Okay, thank you. All right, you're free to go. We'll see you in a couple of weeks.
Thank you, Judge.
And then you have Tammy Farrell. Mr. Lewis. Good morning, ma'am. Is it Farrell or Farrell?
Farrell.
And will your client waive the formal reading of the indictment?
She does, Judge.
Ms. Farrell, in cause number 23, DCCR 1088, you're charged with My computer's slowing down, sorry. You're charged with the state jail felony offense of credit or debit card abuse from August 4th of 2021. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation. There would not be a fine. There would be restitution paid in the amount of $15,516. And you would be required to follow all of the other rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Farrell's not competent?
No.
And what about history or waiving the pre-sentence report, since we have that restitution
The
amount?
state's okay with waiving the PSI. I only show 2 misdemeanor convictions, one from a theft from over 20 years ago, another DWI from about a little more than 10 years ago.
All right, so Ms. Farrell, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and however, I'm going to follow the agreement and defer all proceedings. You are placed on probation for 5 years. You're ordered to pay the restitution in the amount of $15,516 and to follow all of the rules and requirements of probation. If you do that, then this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you could be brought back into court, you could be found guilty, and you could go to the state jail prison for up to 2 years. Do you understand? $15,000 is a lot of money to pay back. 5 years might seem like a while, but it's not. It's very important that you start making payments on that immediately. Even if it's a little bit every month, then it will add up, because what can happen is, let's say you do 4.5 years of probation correctly in every way except paying that restitution, and I make a finding at the end of that probation that you could have paid, then your probation can be revoked and you could still go to the state jail prison for 2 years. Do you understand? It's very important that this gets paid back. I want it to be a priority. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. She's at that desk right there, so watch for her to call you up. Good luck to you, ma'am.
Thank you, Judge.
Yeah. Let's see, on Martin Ward, Mr. Rennick? Hold on, Martin Ward?
I had a quick question for the court. Do I have an order that would reduce this to a Class C misdemeanor? My client would like to plead no contest because it's civil suit against the complainant. And I want to see if the court will allow that. Because I know that you have hesitancy to allow no contest.
Based on that, do you have any issue? Based on the nature of that, I would be okay with it.
Okay, that's all.
Thank you for asking, though, typically.
I want to make sure.
Okay.
I get with him, and then I'll have the paperwork done just to make sure.
Okay, I'll hold it while y'all do that paperwork. See, Mr. Lewis, you've got Edward Frank. I'm signing a dismissal in that right now. He's free to go.
Just for the record, reflect on that, that was at the request of, in that meeting at the office.
Thank you. Is DeAndre Smith here? Mr. Smith, have you heard from Mr. Frank this morning?
Yes, ma'am. I think it's still in Houston.
Okay, but he's coming?
He was supposed to come, so I got ordered.
Okay. To do what?
He got or reschedule date.
Okay, well, he doesn't get to do that the day of court. So if you know how to get in touch with him, you can step out and send him a message. We've been trying to call him, but it's important that he does that before today. So he needs to email or check in with the clerk. If you have a number,
Yes, ma'am.
okay, see what you can find out and come back in and let us know, okay?
Yes, ma'am.
Thank you. I feel like he comes all the time without him. It's so frustrating. Mr. Lewis, you've got Paul McCorvey.
Yes, ma'am.
Mr. Kimler, can you move your chair out of the way, please? Good morning, you're Paul McCorvey?
Yes, ma'am.
And this is 24 DCCR 1914. Mr. McCorvey is charged with theft of property, and what is the announcement?
Judge, this was the one that it's taken a while to get some things from probate court, which we did by the last setting.
Right.
It was reset because we was trying to confirm restitution amount with the complainant. She won't talk with us. I think the issue is Mr. Hoffmeyer is going to try to get with the investigator, see if they can confirm an amount. Because basically the restitution was going to resolve the.
Right.
Correct, Judge, and the notes, according to Mr. Hoffbauer, are that based on that probate order, just a very short conversation with the complainant. Now we have that transcript should get us to a figure that should be able to resolve.
Okay.
And I can make sure that.
If you would, because that's where I thought we
Right.
were last time. And so if you'll get with him and make sure Mr. Hoffpower gets on that quickly so that we don't have another reset based on that, please,
I will,
ma'am.
Judge. I'll bring
Thank
it.
you. All right, stay in touch with Mr. Lewis and he'll let you know when you need to be back. Mr. Kelly, you've got Ashley Sanders.
Yes, sir.
Ashley Sanders. Good morning, you're Ashley Sanders. This is 24 DCCR 1650. We were waiting on audit. Where are we?
Judge, I'm happy to announce, thank you for the court being so lenient with us and resending this a few times. Mr. Wimberly is actually here this morning with his client, my complainant. They did send me some documentation just right before docket. He's also indicated that his office is this week making notebooks for Mr. Kelly and myself and having everything scanned in. If we may just have one final, now that we have all that information, hopefully we can I can sit down with them, then Mr. Kelly and I can sit down and discuss it and see where we're going and be ready to finally announce next time. But I did want to remember we do have all that documentation ordered.
Okay.
It should be to me this week.
All right. Thank you, Mr. Wimberly. All right, so what I'm going to do,
And if you want to go ahead and put it on the trial docket, Judge.
no.
I certainly would understand.
Yeah, no, I just want to, let's see.
My only concern when I hear notebook is.
That's what I'm
kinda
thinking as well.
what we're talking about.
Yes, sir.
We'll be about that thing.
Okay.
With all the tech.
So why don't we do this? When we come back next time, I want it all done and I want an answer. And so what I'm going to do is reset it to the 1st of January. That should be about a 60-day, little more than that. I want everything hopefully turned over this week That gives you an opportunity. So unless there's something else that comes up, I want it all gone through in an announcement at the next court date. Okay? All right, you're free to go. Thank you, sir.
Thank you.
Thank you, Mr. Kelly. I don't know how long that is, probably 70, whatever. And to make that note on it, would you, that he was here, and just so I don't forget. Have we seen Mr. Gertz? I thought I saw him. And then Mr. Kimmler's working on something there. Mr. Rennick's working on his. Mr. Vasquez, were you working on paperwork on yours? Okay, as soon as I'll take care of it in just a minute, as soon as it comes through.
5 times this morning.
I'll just text me.
Fire on the other hand. No.
All right, ma'am, you're Brianna Clanan. And will your client waive the formal reading of the indictment?
She will.
Ms. Clanan, in cause number 25, DCCR 0446, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from March 8th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler? Do you fully understand them? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $250 fine.
I'll explain my scribbles, Your Honor.
Oh, that's CCCR. There would be
Yes,
a
there's
dismissal in cause number 25 CCCR 1119, and this will run concurrently with 25 CCCR
1053.
1053. Is that your understanding?
There should be another misdemeanor.
It was refused.
I was refused.
And what are those cases?
The dismissed one is resisting arrest, and they're all connected to this, Your Honor.
Mm-hmm.
The dismissal is a resisting arrest. The case to be pled is a DWI.
Okay.
All have the same episode.
Let me look at something real quick. Oh goodness, I can't see that. If I test you this morning, will you be clean?
Be honest.
Have a seat in the jury box. Have a seat in the jury. Have a seat in the jury box. Let's get you tested. You can tell from those eyes. As bloodshot as they can be.
She says it's just marijuana.
Just, yeah.
It's not,
Okay.
How'd she get here this morning?
yeah.
How'd she get here this morning?
She's got her sister with her. I don't know how to drive.
Find out for me.
She said it was like 30 days ago, so.
It's not what it looks like.
She was transported by her sister. She's present. The court wants to question her.
Let's see, Mr. Kimler, Ryan Hodge. Good morning, are you Ryan Hodge?
Yes, ma'am.
And Mr. Hodge is charged in cause number 24, DCCR 1167. With the third-degree felony offense of evading arrest or detention with the use of a vehicle. The indictment alleges a prior burglary from 2015, and then also felony of bribing an officer in 2018, and possession of a firearm by a felon in 2018. We had reset that as well, some other stuff as well.
Those are out of state.
Yep. So what that means, though, is for punishment purposes, if Mr. Hodge, if you're found guilty by a jury, you would be considered a habitual offender, which means your minimum punishment, if you go to trial and are found guilty, is 25 years in prison, up to 99 years or life in prison. Do you understand? And we reset this case for you guys to watch the video, and have you had an opportunity to review the video in this case?
I've seen it prior, like,
You've seen the video?
I think he's seen it with his prior.
Okay,
previous
so you've
attorney.
seen the video, and have you talked to Mr. Kimmler about it? Answer out loud. Have you
We've talked about the video.
We've talked about it, yes, ma'am.
Okay, and I want to make sure, so I have here on the tablet a plea bargain rejection that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on count one only, which is just the offense of evading arrest or detention, not those prior offenses, for a cap of 10 years, which means you would leave your punishment up to me. I can give you 10 years, I can give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and have your case set for trial. I just want to make sure you understand what your possible consequences are and what your options are. And do you understand all of that? And so I'm also making the notation here on that plea bargain rejection that I've admonished you as to what the minimum will be if you're found guilty, which is 25 years in prison. You understand? And you want to reject that and have your case set for trial.
I was just
He's maintained his innocence.
All right, then I do want to make sure you understand that after today, I will not accept a plea agreement. I'll get your case set on the trial docket. There won't be a plea. We'll let a jury decide, okay?
So, for any reason, we can't look into it further? The facts and the evidence?
Well, that's what a jury's for. And so your attorney has discussed the case with the assistant district attorney. Their position is that it's an evading and they think they can prove that, and that's what we're going to go to trial, okay? That's what a jury's for. All right? Hold on a second.
have offered in this case if the court is willing to accept it after the PSI.
Okay, and she'll waive the formal reading of the indictment in each.
Yes, sure.
So, Ms. Randall, in clause number 25, DCCR 0246, you're charged with a state jail felony offense of theft of property with previous convictions. And that one's from November 21st of 2024. The indictment alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985, both misdemeanors, which would get us to this state jail felony level. It further alleges that you were convicted of a non-state jail felony offense of theft April 10th of 1989, and then again November 12th of 1991, and then after that was final, October 10th of 1994. And how do you plead to that charge? And are those prior offenses true? Or prior convictions true, excuse me. Are you entering your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? All right, give me just a second to get this pulled up so I can make that notation. I think that was 1 through 5.
Five or six, depending on how we want to look at it.
Okay, and then so much quicker to go paperless, right?
Everything will be better when we go live.
Okay, in cause number 25, DCCR 0247, you're also charged with a state jail felony offense of theft of property with previous convictions from November 16th of 2024. This indictment also alleges you were previously convicted of theft April 4th of 1984 and April 11th of 1985 in misdemeanor cases, and that you were convicted April 10th of 1989, November 12th of 1991, and October 10th of 1994 in non-state jail felony thefts. And how do you plead to that charge? And are those prior convictions true? And again, did you enter your plea of guilty and true freely and voluntarily? And because you did what they've charged you with. In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 4 years in the institutional division of the Texas Department of Corrections, which means you're leaving your punishment up to me. And if I follow this agreement, it means that I cannot give you more than 4 years in prison. I can give you 4 years in prison, I can give you less. It'll all depend on the information that's brought to me and I see at a punishment hearing. You have every right to have a jury come in and determine 2 things. The first is if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? All right, state tenders number 1 in each case.
No objection.
It's admitted. And do you also understand, ma'am, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Is there any evidence that Ms. Randall's not competent?
No, Your Honor.
All right, Ms. Randall, I'm going to find in each of your cases that you entered your pleas of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence to find you guilty in each of your cases. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information on you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information information to Mr. Vasquez, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
Yes, sir. Mr. Gertz, you have Shay Morgan. Good morning.
How are you?
Good. How are you?
Hectic.
It's a Monday.
It was supposed to be a slow Monday, and it's turned into the opposite thing.
That's usually how it goes. Good morning. You're Shay Morgan? And Ms. Morgan, in cause number 24, DCCR 2102, is charged with theft of property. And what is the announcement?
Judge, we're going to ask for a regular resetting. Ms. Malfino and I are discussing a potential resolution. I've also been given some documents from my client that I think will help inform that process. And so,
any issues?
No, Judge, it looks like we do, at least for purposes of this announcement, have a restitution figure, so we would need time to develop that.
Okay.
We can just share that information with the council.
Okay. And the case looks old, but I realize that you were just hired in the end of July, so we'll just do a normal reset. And then, Ms. Morgan, make sure you stay in touch with Mr. Gertz so you guys can go over everything. We'll try to get an announcement at the next court date. All right, you're free to go. Thank you.
have a good week.
Thank you. You too.
I guess I'll see you tomorrow.
You have something, maybe?
If they make me a fire sale offer, maybe I can.
We'll see. And Mr. Rennick is, I guess is Mr. Rennick out there doing paperwork?
I'm signing it right now.
Okay, thanks.
How many years have you been doing this?
true.
Ms. Clayton, come back up.
Get away off the devil's trap.
All right, you're Brianna Clayton? Not very smart to be doing anything while you're waiting on court, is it? How old are you? You're 20. So it is time to make better decisions, because smoking marijuana or anything else that has THC in it is going to be a violation of any probation, and it can put you in prison. It's that serious for you to get your life on a different direction. Make sense? All right. Now I can't remember how far I got at all. Let's start over. And she'll waive the formal reading of the indictment.
So wait,
Did I go through it all or no?
you got real close. We had just mentioned the misdemeanor cases. One was being dismissed, one was being run concurrent.
Okay. So we've already gone through and she entered her plea of guilty. We went through, it was a 3-year deferred, $250 fine. All right, so we're gonna start back where we left off, Ms. Clayton, and let me go back and ask, did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? And then you understand what your punishment is that you're agreeing to, which is a 3-year deferred with a $250 fine, correct? With the dismissal in one of the misdemeanors, and then my understanding is you're gonna go plea on the other misdemeanor for a probation as well, correct? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Clayton is not competent?
None that I'm aware of, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If you test positive for anything between now and when you come back, you run the risk of me not accepting your plea agreement. Do you understand? I want her tested when she goes in for her PSI.
That's alcohol.
And I ran, yeah, that's alcohol also. You don't need to be using anything. No alcohol. You're not even legal to drink alcohol. So by your reaction to Mr. Kimmler, it shows me that you're doing that as well. You understand you can go to prison for 10 years because of this? What y'all did, I mean, y'all jumped out of the car and hid and ran and all kinds of stuff. And it's not funny.
I'm not trying, I laugh when I get nervous.
Okay. I mean, you're lucky that this didn't turn out worse with you guys running and hiding from the police. It could have been very bad. So if you want your life to go in a whole different direction, you're going to have to make some much better choices. Okay? All right, so you need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there, and we'll see you back at sentencing.
Thank you, Your Honor.